On this morning's docket, case number 109355 in the matter of AMMH. And counsel, as I asked prior counsel, since we have some students in the audience, could you spend maybe 30 seconds describing the facts of the case, trying to avoid the specifics of the crime? All right, thank you.
I'll do that, thank you, Your Honor. And Your Honor, I'd like to reserve 2 minutes for rebuttal, if I may.
2 minutes is granted.
This is a case in which the respondent was found guilty of a felony in juvenile court, and as part of the Kansas sentencing procedure, he was given both a juvenile sentence and an adult sentence was calculated at the same time. He was then transferred to the juvenile correctional facility. He served that juvenile sentence. He was placed on aftercare, which is a period of conditional release. He did violate requirements of that conditional release.
I'll ask this question in a minute. Remind me to come back to technical.
We then returned to court, and pursuant to statute, the court found that he had violated the conditions of the juvenile sentence and then invoked the adult sentence and remanded him to the adult penitentiary. So the question for us is whether the violations of those conditional release requirements that were drafted by the commissioner of JJA or by parole officers, in essence, constituted a violation of the conditions of the juvenile sentence. Significantly,
Here's my quick question.
okay.
These violations are repeatedly referred to in the briefs as technical. What makes them technical?
Well,
If you run away from probation, that's pretty basic, isn't
yeah,
it?
and
not
I
like
think
having one
I think it
for
grows out of criminal work where there's a distinction between violating probation with a technical violation and violating probation by committing a new crime.
Well, there's a
Okay,
distinction here.
That's
too.
the term of art you're using.
Yes.
Okay, that's what I assumed, but I was a little confused
Yeah, I
by
didn't.
it.
I mean, I didn't mean to minimize them, but they're not violations.
It's a
They're not
non-new crime
Right.
violation.
Right. And the EJJ piece has a second prong that says and not violate the law.
Right.
So there
That's
is some
another way to do it.
significance there.
Do we need to find the act, the various provisions of the act to be either ambiguous or in a reconcilable conflict, and then apply the rule of lenity in order for us to rule in your favor?
Well, I think so. I mean, I think you have to construe it strictly as a penal statute. That, you know, there are different terms used in different sections of the statute, but they're used interchangeably in this procedure. And I don't think they are interchangeable. That's the point of the appeal. We've got the term conditions of the juvenile sentence. And I think what the legislature intended when they set this up most likely was get probation, but have an underlying adult sentence you have to serve. I don't know that this turn of events was anticipated when they drafted the statute.
Why do we have to find an ambiguity? Where we are is that the adult sentence is stayed on condition that the juvenile offender not violate, quote, the provisions of the juvenile sentence, end quote. We can simply say the juvenile sentence means the sentence, not the parole or the conditional release, because we, you know.
Right.
So here's my question. If that was what I think we maybe were miscommunicating. I'm trying to ask if that's your only avenue to find ambiguity or irreconcilability and then apply the rule of lenity, or whether you have a statutory argument. And I think what Justice Johnson's suggesting is that you have a statutory argument. And then my question arising out of that is, the aftercare was ordered by the judge. The aftercare was ordered by the judge as part of the juvenile sentence. Aftercare, they're not generally going to be released with no conditions, correct? I mean, have you ever seen a case where they're released with no conditions for aftercare?
No, I haven't.
Okay, so it appears to me that aftercare and any conditions that go with it are part of the sentence, the juvenile sentence. That's why I was asking you if you have to go the ambiguity plus lenity route because you are without a statutory argument. And that, if you can kind of respond to all of that at once, that'd be terrific.
Well, I will try to. I'm construing what the conditions of the juvenile sentence means, and I think if we construe that strictly, the judge's conditions were that he serve his time in the juvenile correctional facility.
Mm-hmm.
The
That's
judge,
it. What's the condition? You just
the-
sent him away for 2 years, right? To the juvenile corrections.
Right. The judge made no further conditions.
Right. What might the conditions be? If you're going to prison or to juvie lockup for 2 years, what conditions? I mean, what does that mean?
Serve the sentence.
Yeah,
Don't
exactly.
escape.
That's not don't escape.
You know,
Okay,
and I
that
think where this started was we're gonna allow juveniles to do probation with an adult sentence hanging out there. I don't know that this was envisioned by the legislature when they set this scheme up.
There's a reference in the statutes to the portion of time that would be served in a facility plus aftercare, isn't there? So, I mean, how can we say it wasn't contemplated that some juveniles would get a juvenile period of incarceration with the adult incarceration hanging over their head?
Well,
It may be that the
if they
normal
if
is
they
probation.
violated the law, it's going to be triggered.
That doesn't, I don't think that's responsive to my question. I mean, I don't think you can say as a blanket matter that the legislature did not contemplate that some of these extended juvenile jurisdiction folks would be subject to both incarceration as a juvenile with incarceration as an adult hanging over their head. Because there's a reference to the kind of sentence this juvenile received, isn't there? A period of incarceration followed by
Yes, I think there
aftercare.
is.
I think there is. So I think that torpedoes that argument.
And I
What's your
think that-
next best?
We've
That-
got the conditional release requirements that the judge has no part in drafting. The judge doesn't order those. The judge has actually no power to create those. Apparently, the juvenile has no power to challenge those in front of a judge. Apparently, JJA lets the judge know that a kid is about to be released. The judge may recommend some conditions.
That's what I was wondering, if you wouldn't analogize to adult court where we've said that the judge doesn't set conditions of parole.
Well, you don't,
Thank you.
this is completely different from that, from adult court in that sense. But we could be stuck here where the judge is forced, as part of the judge's sentence, apparently to enforce a provision that the judge doesn't want to have in the sentence of the case, as part of that judge's sentence. These requirements are established by JJA and the probation department. They may take effect even if the judge doesn't want those to be ordered as part of the conditional release. Additionally, when a juvenile is released, the juvenile signs paperwork, the paperwork that creates these conditions, that spells out what the sanctions are for violating them. And nowhere is it mentioned that you are subject to having the juvenile sentence revoked and have the adult sentence imposed. And indeed, one of the statutes that talks about what happens if a violation of conditional release occurs leaves out the option for imposing an adult sentence.
Doesn't it say make other orders?
Make
as
other
appropriate?
orders, and that was added after. I think that was added years after this EJJP procedure was set up.
But before your client was
Yes, yes.
implicated, right?
And I think that that language that's the question here, is whether this is an appropriate order or not. I don't read that as a grant of authority for the court to do anything that may turn out to be reasonable.
Well, let's analogize to an adult proceeding, a post-release supervision. The conditions of that are set by the parole board, correct?
Yes.
But isn't that also part of the sentence?
It is considered part of the sentence. Those aren't conditions of the sentence, though.
It's not part of the sentence insofar as it counts for time served.
Right, right.
We've had case law. I'm trying to get to the point where, you know, it actually says not violate the provisions of the juvenile sentence and not commit a new offense. That's the 2364A 1 and 2. So why, if the adult court judge orders, makes a sentence, but the conditions are established by the parole board, why is that any different than here where the judge orders incarceration and makes the sentence and aftercare, and the aftercare conditions are established by the facility? Why aren't they both the sentence?
Well, we've got conditions of the sentence in there, in the juvenile case.
Says
So
provisions.
provisions,
Is the language
the
of the
provisions of the sentence. We don't have that in adult, but in the adult situation, if there's a violation, that's an administrative proceeding in front of the parole board. It's not a return trip to court like we have in the juvenile system. So there is a difference. I mean, because it used to be that administrative proceeding, half the statutes assume there's this proceeding to simply revoke the conditional release. That's what the respondent was told in writing when he signed these requirements that JJA drafted, that now apparently constitute conditions of his juvenile sentence.
Why do we have 3 different contracts that say conflicting things?
Well,
Do you have any idea? I just am curious on that point.
it's simply, it's an agency that has paper, I mean.
Feels compelled to duplicate itself?
Yes.
Okay, that's all. That was just a curious question.
I think if we strictly construe the statutory scheme, we see that the respondent didn't actually violate the provisions of the juvenile sentence that were ordered. He may well have violated the requirements of the conditional release contracts that he signed. But those are 2 different terms, and I don't think they should be read synonymously when we must strictly construe statutes that have a penal effect like these statutes do.
But you agree that if the court, instead of sending to the juvenile correctional facility, had placed this juvenile on probation and established conditions, that would be a violation of the provisions of the sentence?
If his actions violated those requirements, those probation requirements that the court ordered at sentencing.
Any further presentation?
That's all I have. Thank you.
Any more questions of council? Thank you, council.
May it please the court, Sean Minahan for the state of Kansas. I prepared this argument this weekend using a certain angle of the argument, and I came here and I started reading the briefs, and I decided to change the whole angle. Now that I've listened to the questions, I don't know, maybe I should go back to my original idea. When a court, when a juvenile is adjudicated as a juvenile offender in just a regular case, not an extended case that we have in this case, the court has to look to 382361 to determine what options he has when imposing disposition, so to speak. In this case, they chose A12, which is confinement in a juvenile correctional facility. Then the court has to look at 2369 to determine, now that I've decided to send him to a juvenile correctional facility with an aftercare, what sentence do I need to impose on him? And in this case, he received a 24-month sentence and a 24-month post-release, basically, aftercare term, conditional release. Then you get to the point where, okay, what if he violates some condition during that? And then you look at either 2369 or 2375. And it's a little odd that the legislature would have two provisions that kind of deal with the revocation of a juvenile sentence. All of these statutes are related to just a typical juvenile case, a case where somebody goes through the system as a juvenile, not one where you have the EJJP or whatever. But if the juvenile is adjudicated under the EJJP, you look to 2364. And if you look at the language in that statute, it not only talks about revocation of the probation, it talks about the procedure that you take. And it's the state's argument that under this, you don't look at, under this extended, the EJJP, you don't look at 2369 and 2375. You look at the language of 2364 to revoke on that. And I suppose there's a couple of ways you can look at it. First, you can look at it, as I just said, where you ignore those statutes. Or you could look at it, this court could look at it as the 2364 being the more specific statute when it comes to revocation on EJJP cases. So I think that all of this hemming and hawing about 2369 violation of probation and 2375 really doesn't apply to this case.
Well, how does 2364 help you?
Well, it's the statute that explains that if there's a violation of conditions of probation, that the court shall impose the underlying adult sentence.
2364B.
Yeah.
It
Yes.
shall do that if it finds a violation.
Right. And I think that the difference between the two analyses is that if you, and I would argue that you should just follow 2364, but if you say that this is the more specific offense or the more specific case, then a court may be able to look at the other types of penalties in 2369 and 2375.
Doesn't A2 come into play? 2364 A2 is the condition that says you've stayed the adult sentence on condition that the juvenile offender not violate the provisions of the juvenile sentence or commit a new crime.
Right.
And so why are we not still back to whether the conditions of release are a provision or are provisions of the juvenile sentence?
Right, and this is kind of the rub that I had with the two ways that I was going to argue this case, is even though I go through this whole scenario, that it really only addresses whether this court should even consider 2369 and 2375 in determining the revocation. The next step is, well, then is this really a condition of probation that he violated? And I would point out that, and the Court of Appeals, I think, pointed this out also, but it's volume 1 of 43. One of the provisions of the sentence was to follow any conditional release terms opposed. The court actually imposed that as a condition of its
Well,
sentence.
that, the court ordered that at a permanency hearing. The court recited at a permanency hearing that this particular juvenile was to follow the conditional release conditions. That's a little different than it being part of the originally imposed juvenile sentence.
Yeah, I'd have to look at the site. there,
After he was released from the
Right.
juvenile correctional facility, they had a permanency hearing.
Right.
At that permanency hearing, the judge says, you shall follow the conditions of release.
Right.
But is that tantamount to modification of sentence, or is that a reiteration of the sentence? Or
Well, it
is
would
that
be
part?
It would be a reiteration of the sentence. One thing I would point out is that kind of implicit in saying that you have to, so I don't know what you follow the conditions of your sentence, is that you successfully complete those. What kind of condition could you violate if you're in prison? I suppose, escaping. But how do you violate a conditional release if it doesn't mean that you're violating conditions you're required to follow? And I would also point out that as this court already said earlier, that in parole cases and probation cases, very rarely do you see, unless it's some special condition, very rarely do you see the judge state on the record the conditions that they must follow. Once in a while you do, and sometimes we see these special conditions come up, but that's also similar to the case where we have restitution. Restitution is a part of a defendant's sentence in in an adult case. But we've also said, I think, just recently, and a few weeks ago, when we had a restitution case, that the court isn't imposing that at the time. He's imposing it as a sentence, but the amount of it is really determined, imposed after he gets out of prison and he's serving probation. Unless this court has any other questions.
Just to be clear, the language in 2364 that you're relying on appears two places and is slightly different. 2364A2 talks about the provisions of the juvenile sentence.
Mm-hmm.
And then 2364B talks about violating one or more conditions of the juvenile sentence.
Right.
Are you saying conditions and provisions are synonymous?
I'm sorry, where was the provisions? Okay, here we go in 2.
Yeah,
Right.
A2 is the first mention that talks about the stay of the adult sentence pending completion of the others, and then the 2364B talks about what can happen when there's been an alleged violation of the one or more conditions. You're
Right,
saying those mean the same thing
yeah.
in 2364?
Yeah, I think the legislature is playing loose with words. That they should be consistent with these things, but oftentimes we see this all the time. They're not.
That was a fairly quick attack of amnesia. Okay, thanks.
But unless this court has any.
Any further questions? Thank you, counsel.
Thank you.
You reserve 2 minutes for rebuttal.
I have nothing to add, thank you.
Any questions of counsel? I see none. Thank you both for your arguments this morning. Court will take this matter under advisement.